All right.
All right, so we'll now get into what is the meat of this workshop, which deals with union right to grievance information. I have a long chapter, a relatively long chapter in my handbook on this topic, and I've written several articles for TDU and for Labor Notes going over various aspects of this area of labor law. This is an area of labor law that I feel good about. It has survived. It survived the Reagan administration. And to tell you the truth, it survived the Trump administration. It was the one area of labor law that did not take a big hit when the Trump Labor Board took office. If Trump had won re-election, I'm absolutely certain that the board would have gotten around to issuing decisions on union right to information and make a big attempt to limit them, probably by requiring that unions take information disputes to arbitration rather than go to the labor board. But the Trump board got kicked out before it's going to, well, the Trump got kicked out and the board will be turned out fairly soon. And the union right to information has survived that potential battle. Every union should be familiar with information requests and how to make them and when to make them and how to use them. We win a lot of grievances a lot of times by making a good information request. Either one, we get information that we can use to win the grievance, or two, the employer doesn't want to answer the information request, doesn't want to provide the documents, the notes, the videotapes that we are asking for, are insisting on, and settles the grievance with the union because it doesn't want to provide the information. So I encourage unions to file information requests frequently throughout the year. In fact, I would say I can hardly imagine a grievance that you would file where you would not submit an information request, either with the grievance, because we have many choices. When we write our grievance, we can attach the information request to the grievance, and we can say in the grievance, this grievance concerns discharge without just cause of so-and-so. We are asking that he be made whole, and we are asking you to respond to the attached information request, so we can attach the information request to the grievance, or we can file the grievance and then file a separate information request the day after or the week after. And we can even file multiple information requests for the same grievance. We're not limited to one information request. Many times we will file an information request, obtain something from the employer, some data, some records, go through those records, and then file a second information request with additional items on the request. And I encourage unions to be militant about this area of labor law. We win most charges that we file at the NLRB. The law is tilted heavily in union favor. We are entitled to a lot of information that you wouldn't expect. Employers don't understand this area of law. They always get surprised. And I would ask that you be rigorous in enforcing your rights. I'll never forget when there was a union in Massachusetts. It was a public sector union. It was a social worker union. And the chief steward of that union made it her duty to master this subject area. And she followed the idea of filing a detailed information request each time she filed a grievance. And that information request would have 5, 10, or perhaps even 15 items, all numbered 1 to 15. And she would give the employer 2 weeks, and she would ask the employer to respond within 2 weeks. And at the end of the 2 weeks, she would, obviously, if the employer made no response, she would file a charge at the state labor board, because she was a public sector employee. Now, if the request was for 10 items and the employer provided information, say, for 3 and ignored the other 7 or denied the other 7, she would file a charge at the labor board for the other 7. Now, if she filed a request for 10 items and the employer provided 9 of those items, now some stewards might say, well, I got 9, I asked for 10. That's pretty good. I didn't expect to get that many. We can probably live with this. She didn't live with it. If she got 9 out of 10, she filed a charge at the labor board, the state labor board, for the 10th item. And she took the position that every item on my list is relevant to the grievance. Every item on my list is part of my investigation or to prepare me to present the grievance. And I want you to give us, I insist that you give me all 10 items. And if you don't, I'm going to take and push them to issue a complaint against you. And after some time taking that posture, the employer was really sort of changed the way it operated. Before, with other chief stewards, it didn't think much about violating the contract or abusing workers' rights or assignment practices or promotions. It tried to follow seniority and the other parts of the contract. But it also, it tried to follow those things, but it often violated the contract. I guess that's my point. Once this new chief steward took office, it became much harder for the employer to violate the contract. That's my point. That it wasn't just a question of, I violate the contract, I will meet with you for a grievance meeting, 1 step, 2 steps. Now, if I violate the contract, you're going to make me provide reams of data, documents, notes, files that I don't otherwise want to give you. It made it more onerous for the employer to violate the contract. And the employer took a new approach towards its obligations. So that's the point I want to make there. Let's see if we can get to the next. For some reason, I'm not advancing. Oh, yes, here we go. All right. My up and down arrows don't seem to be working correctly. When can grievance information be requested? Well,
there's no volume.
Robert, your mic is muted.
Bob, we had to mute all participants because of the background noise. So now you need to unmute yourself.
Okay. All right. Okay. Now I'm going to do screen share, get back to that. Okay. I'm back. Can you hear me now?
Yes, thank you.
Okay.
Sorry about that.
Yes.
All right. All right. As I was saying, employers may take the position that we have to wait until a grievance is filed before we can file a request for information. That's not correct. We have the ability to file information requests, and the employer has to comply with those requests way in advance of filing a grievance. For example, we have the legal right to file information requests, and another word for information requests is RFI, request for information. We have the ability to file an RFI to monitor the workplace or to police the workplace. And this can be very effective for the union. For example, one of the big issues in any union is temporary employees. Someone shows up, you come to work on Monday and there's a new worker doing the job, doing union work. And the employer, when you ask the employer, when did you hire this fellow? He says, this is a temporary employee and he's not part of the union. We don't want to be in the dark about temporary employees. We have the right periodically to submit requests to the employer to give us a list of all temporaries who are hired and who are working in the workplace, what their jobs are, when they were hired, and what their pay rate is. And even if you want to push it, how did you get this worker? Through what, temporary employment agency or transfer from another job site or whatever. That's information which is relevant to us to monitor the workplace and to decide whether the contract has been violated, whether that person should be in the union or whether the employer has violated the contract by paying a wage below the union rate. We also might want to submit a RFI to know certain information periodically through the year. Please give us a list of all employees who have applied for FMLA leave over the last 6 months and what decision was made on their request. That's a monitoring type of a RFI. Please give us the names of all employees who have been disciplined over the last month and a copy of their disciplinary announcement. That's a monitoring type of a thing. Please give us records showing your contributions to the union pension plan for each employee, which indicate how the amount and how it was computed. Please give us a list of how you allocated overtime over the last 6 months or over the last month, so we can make sure that it was allocated in a non-discriminatory fashion. This is using RFIs to monitor the workplace and to police the contract. Second time we'll be filing RFIs is to investigate whether to file a grievance. That is, we are suspicious that a contract violation has occurred. We need to investigate. A worker has come to us with a complaint that he didn't get a job assignment per the contract, that he didn't get overtime per the contract. So we need to investigate. As part of the investigation, and before we have even filed that grievance, we submit an information request to the employer, and we ask him to provide it. However, if we are facing a grievance deadline, we understand that if we're facing a 5-day or 10-day grievance deadline, filing an RFI for information doesn't stay the deadline, doesn't put it off. We're still under that deadline, so we may file the grievance even before we get the information. In fact, we need to do that to avoid losing the grievance and having a problem with the employee. The third event that triggers RFIs is when we have a grievance meeting coming up and we have to get ready for that grievance meeting. And in preparation for that grievance meeting, we want to see various documents, various personnel, especially personnel files of the grievant, of other employees, of witnesses. We want witness statements. We want to know if the employer has interviewed people that led to the discipline. We want to have those notes. If we're grieving a decision that the employer made to assign work or to relocate work, we want to have the records, all records relating to that decision, who made the decision, when it was made, any studies that were commissioned by the employer that led to the decision to relocate or reassign. And then the fourth stage where we're going to be asking for information is to prepare for arbitration. We have an arbitration coming up in 2 or 3 weeks. We may have requested information for the grievance, but now we're getting to a more formal proceeding where we're going to be putting records as exhibits into the record, and we review the case. Maybe we go over it with our attorney, and we come up with another list of 5 or 10 items that we need for the arbitration. We have the right to submit another information request at that point. The employer might say, well, you should take that to the arbitrator, but the labor board does not defer information requests, and we don't accept that. No, we want you to provide the information pursuant to your obligations under the NLRA. What information can be requested? That's a big topic. There's hundreds of different types of information that we can ask for, but I think it might help you to think about it in terms of 3 subcategories: documents, data, and facts. Documents, well, there's an infinite amount of documents that might be relevant. to investigating a grievance or to presenting a grievance. Just to list them quickly: personnel files, attendance reports, customer complaints, employee evaluations, interview notes, investigative files, studies, and videotapes. Let's briefly go over some of these, the list. Personnel files. This is an essential document that we're going to be asking for. Certainly, we want the personnel file of the grievant. If we're representing a grievant who has been disciplined, or a grievant who has been passed over for a promotion, or a grievant who has been demoted, we want that employee's personnel file so we can review it. And we don't want to go to a grievance meeting or an arbitration and be surprised when the employer says, well, I don't know why you're bringing this grievance. This is the worst employee in the whole shop, and he has been rebuked many times for bad work and bad attitude, etc. We don't want to be surprised. We want to know that before the first step grievance meeting. So we will almost reflexively ask for the personnel file of the grievant. We will also, in many cases, ask for the personnel files of other employees. We would, for example, in a discipline case, we know that one of the best ways to win a discipline case is to show that other employees, one or hopefully more than one, who committed the same level of discipline of infraction, got a significantly lower penalty. The fellow we're representing got a 10-day suspension. We know that other workers who did the same crime, so to speak, got significantly lesser penalties, such as a 1-day suspension or a written warning. That's it. In that kind of a case, we can win the case based on disparate treatment, but only if there's no other reason why that employee got a favorable treatment. There wasn't something in his record or his background that warranted special favorable treatment. For example, an employer might give one worker a harsh penalty for, say, speeding, if you're a driver. Another worker might get a lower penalty. Why? Well, he might be he might have various commendations in his record, positive aspects of his record where he volunteered to help the company, or came up with ideas, or he's got a great attitude. His personnel, his evaluations show him to have a positive attitude over the years. He may have more seniority. So we want to know everything. We want the files of other employees who got lesser discipline. We also probably want to have the files of employees who reported our work. If our worker is in trouble because other workers complained about him or reported him or informed on him, so to speak, well, let's get the personnel file of the informer, because by going through that file, we may find information that we can use to discredit the informer in the grievance process. For example, we might find that the employment application of the informer that he lied or she lied. She said she went to college. She said she had a high school graduation. Well, we know she didn't. Well, if she lied on her employment application, then probably she could lie when she complains that so-and-so worker didn't lock out his or her machine or follow other safety protocols, or was late all the time, or left work early, or whatever the complaint is. Attendance report. Let me talk a little bit about personnel files. Sometimes employers say, well, we'll give you the personnel file of the worker who you're representing because he obviously authorizes it. But we're not going to give you the personnel files of any other employees in the bargaining unit unless you give us a written authorization from that worker. We don't accept that. And the law and the NLRB doesn't agree with that, and has issued numerous decisions saying that unions are entitled to the personnel files of the people they represent, whether or not they can obtain written authorization. Or in fact, even if the employee in question notifies the employer he does not want his file turned over to the union. And of course, in many cases where we're talking about disparate treatment, the employee who got favorable treatment, who's probably friendly with the employer in some way, and got special treatment as a result, he doesn't want, or she doesn't want us to have her file, and notifies the employer, don't give my file to the union. That is not a sufficient basis for the employer to prevent, to avoid giving us that employee's file. We press hard on our demands for files, and we do very well when we get those files. Now, it's true that many personnel files are very thick, depending on the company. And this leads sometimes to questions about expense, because the board has said that when there's an unreasonable expense, when there's a significant expense involved in providing us with information, the employer can request that we share the cost, that he can bargain, that we bargain over who's going to pay for the copying costs or the time it takes to put together the materials that we've asked for. And this can come up sometimes on personnel files because they're very thick. So we can be flexible here. We don't always need the whole personnel file. Probably 2/3 of the personnel file are irrelevant to what we're looking for. We don't need everything, every wage increase that worker got over the last 15 years. We can tell the employer, you don't have to include that. One of the best ways to cut down the expense of personnel file requests is to tell the employer to provide the file electronically. If the employer provides it electronically, there's no basis to charge the union any expense for copying. We get the file, we can read it as an attachment and decide what we want to copy to use as evidence or to bring to the grievance meeting. We can also tell the employer not to include certain parts of the file in order to reduce its size. Attendance reports. Certainly if we have an employee who's being disciplined for tardiness or absenteeism, we want his attendance record. We also want the attendance records of the other employees in his department or her department, or in the other employees on the shift, to compare to see if they have we can find at least one other worker who has a record just as severe, just as deleterious as the worker that we're representing or close to it. Customer complaints are very important to us. If the employer has received a letter from a customer complaining about an employee, or got a phone call from a customer, and on that basis begins an investigation, and on that basis eventually imposes discipline, we want the initial complaint. The employer doesn't want to give us that complaint, but we need to have that to investigate as to whether this case was legitimate, if the initial complaint was phony or prejudiced, that covers the whole investigation. NLRB says we're entitled to all written complaints by customers, which lead to discipline. We're also entitled, if it's a telephone call or if it's an in-person complaint, we are entitled to either a summary of the complaint, or if the employer took notes on the phone, as usually happens, when a customer calls, the employer will take a note as to what the customer said. We want those original notes. We're also entitled to employee evaluations. We're going to be asking for these are the annual evaluations or the 6-month evaluations. Now, we can get those in a variety of situations. Sometimes we just, every 6 months, we might say to the employer, give us a copy of all evaluations issued over the last 6 months, because we are concerned that the evaluations are not being done in a fair, non-discriminatory fashion. That's more of a policing type of request. If we're doing a discipline case, we want the evaluations of the grievant, and we want the evaluations of the witnesses against the grievant to see if we can use those to either to show that to build up the grievant or to discredit the witnesses. In a promotion case, if 10 people apply for an opening and one person is chosen and we are challenging that, certainly we have to have the evaluations of the other employees who applied for the opening to see whether we can make use of that in building our case. Interview notes, very important. If the employer has interviewed 3 or 4 people in preparation before it imposed the discipline, as often occurs, we certainly want to know what happened at those interviews. In 90% of the cases, the employer took notes of the interview. The employer assigned the case to someone from human relations, or the supervisor did the interview. We want his or her notes. We also want to know, by the way, if the supervisor made a recommendation based on that interview as to what action should be taken, we want a copy of that recommendation. Now, the employer might say, well, I didn't act on the recommendation. I made my own decision. We still want that recommendation, because if the person who interviewed the witnesses or interviewed the grievant and interviewed the witnesses made a recommendation for a penalty at a low level, and the employer ended up imposing a more severe penalty, well, that helps our case to know that, because we would argue, say, to an arbitrator or to a panel, that the person who knows the case the best recommended a written warning, and the employer brought it up to a 5-day suspension. That doesn't seem right. Sometimes the employers say that, well, you know, you had a steward present at the interview with the grievant, because the grievant understood his Weingarten rights, brought in the steward, and your stewards took notes. You don't need our notes. You can go to the steward's notes. Well, he's got a point, but it's a weak point, because yes, we do have some notes of what happened at the meeting, but we want to know what notes you took. One, because you may have taken notes on points that the steward missed or forgot about. Or two, we want to know what was in front of you when you made the decision to impose discipline. We want to know what you knew when you made that decision. And the steward's notes don't really complete that investigation. Studies. Studies, I think I refer here to many times an employer will commission an outside agency to come in and do a study of productivity, of work attitudes, of cooperation, of procedures. That study then is used to make changes in the workplace. When we know that company is conducting a study, we want that study, because it has implications for safety, has implications for changes in working conditions, and it may even have implications for discipline. We're entitled to the employer's studies. Sometimes we have to agree to some redactions. That is, some things can be blocked out if it's particularly confidential. Last point I'll just bring up now is videotapes. Certainly in the case of transportation workers, we know companies are videotaping everything. And those videotapes are often going to be the basis for adverse action. We want to have those. We want to have those videotapes. Now, the board rule, unfortunately, does not require the employer to make a copy of the videotape and give it to us. It's too bad. That would be a good rule, but maybe it's the expense or the complications. But the board rule, it does provide that we have the right to review the videotapes, to see the videotapes. And we have the right to do that in a somewhat private manner. That is, we want to look at that video. We want to put if it comes on a disk or on a what do you call it? The other thing, on a file that we put into the computer. We sit down with a couple of our members to look at the videotape. We don't want the boss to be sitting at the same table or in the room or close by, because we're going to be talking about what we're seeing. We want to be able to have a free exchange of information while we look at the videotape. So the rule is the employer provides the videotape, allows us to see it, doesn't have to give it to us, doesn't have to make a copy, has to allow us to review the videotape in a semi-private surrounding in which we can have conversations about the videotape without the boss being able to hear us. Now we'll move on to the second major category of information, and that is data. Data means that it's material that is not already collected in a document, an already existing document. It's a document that the employer has to create to satisfy the RFI request. For example, it's a simple one. If we're representing an employee who is suspended for speeding, he got a citation for speeding from the police, we ask for all other employees who were disciplined for the same offense over the past 3 years or over the past 5 years. If we have a small bargaining unit, we might look for a longer period of time to be able to capture other employees who committed the same offense. So we ask for employee discipline for the same offense over the last 3 years. And we also want to know what penalty was imposed. And we also, well, we want a copy of the notice to the employee. But just say the list of employees disciplined for the same offense. Does that document already exist in the employee's records? Does he already have that document? Probably not. He might have it, but in many cases he won't have it. So we are asking him to go to his records or her records or its records and compose the list of discipline. That is data. NLRB requires the employer to create the data document for us to review. We are making the employer work for us. This can be, when you start looking for data, you're asking the employer to really go into its records and to compile information and to put it in a document and list it. It's to do work and to do work for us. And I enjoy making those type of requests, and I enjoy the notion that they have to do that work for us. Now, sometimes the employer responds by saying that there's going to be expense involved in preparing that data, preparing that document. Well, in that case, we don't just accept that. We say, well, what is the projected expense, and what do you base that on, and what is the hourly rate of the employees that you claim are going to be involved in preparing the data? If the total amount of money that the employer is seeking is $100 or even a couple of $200, a big employer, that is not a significant expense. The NLRB doesn't require the union to contribute unless the expense is significant. That is several $100s probably for a medium-sized large employer. Furthermore, we have various abilities to respond to a demand for costs. The employer has to sit down and bargain with us over its request that we contribute, how much we contribute. We might want to reduce. Okay, you're saying it's $200 to go back 5 years. How much will you charge us to go back 3 years? Well, so we might change our request. We say, okay, give us 3 years and then we'll decide whether we want 5 years. Another notion when it comes to data, we want incidents in which, okay, the second bullet point here refers to past practice grievances. Let's get away from discipline grievances for a second. A past practice grievance is a grievance in which we contend that there has been a consistent past practice providing employees with a certain benefit or privilege, which has occurred consistently so consistently over the past period that it becomes part of the contract, part of the understanding, the unwritten understanding between us. And consequently, it's a binding part of the contract. I have a whole little handbook on past practice grievances, which you can get from Labor Notes, the publisher, which gives you some good tips on understanding past practice grievances. But in order to win a past practice grievance, which is one of our more common grievances, we need to show that a practice occurred consistently over a significant period of time. The employer's defense to that is, well, no, it wasn't consistent. Maybe it happened more often than not, but there's numerous occasions on which we did not observe the practice. We did not let people have time off for educational reasons. So we did not let people have time off to go to union meetings. Well, we need to know that. We need to know each of those incidents before we go to step one, or certainly before we go to step 2 or 3. We need to have a list of every incident in which the employer claims it did not follow the past practice, so that we can investigate to see whether there was a special reason why that practice wasn't followed. That does not weaken our case that there is an implied understanding. So this is a very common type of data request. Give us the names, the dates of each incident where the practice was not followed, and the reason why it was not followed. Another typical data request refers to accidents over the past year. Another one would be subcontractors. The names of subcontractors and the work being performed by those subcontractors. A very important issue for every union. And we might well be submitting a subcontractor request periodically through the year, or maybe every 6 months or every 3 months. Give us the names of all current subcontractors and the work being performed. We need to have this to investigate whether to file grievances about failure to, about violating the subcontracting clause or failure to bargain before making a decision to subcontract. Fax, of course, are another major category of information requests. Certainly, we want to have the names of the complainants, the names of witnesses, and the dates that the various infractions occurred. But also, let me give you a tip on another area which I bet many of you are not following. You see where it says the last bullet. In the second step grievance meeting, you said that the grievant, get my own, so I can read it, be blocked by the pictures. You said the grievant had done the same thing several times before. Please describe the date and nature of each incident. So what I'm suggesting here is this. Your grievance process may have 2 or 3 steps. Each time that you go to the grievance step and you have a discussion about the grievance, when that meeting is over, you sit down and you think about that meeting. You go over what happened. Maybe you go over it with the grievant or with anybody else from the union who was present so that you make sure that you don't forget anything. And any point where the employer made allegations against the grievant or against the union or in favor of the company, where he didn't flesh out that allegation, he made a bare-boned allegation without facts, without support, we now go respond the day after the grievance meeting with a RFI request to require the employer to bear out each of the allegations made at the grievance meeting. Now, sometimes the employer can do that quite easily, and then we've gained, maybe we haven't gained anything. On the other hand, if the employer doesn't respond to the grievance, the request, or says, well, we don't have any, that data, we don't have it in writing, or we don't have it, we can use that also. If we ever go to arbitration, we have the fact that you made a decision to discipline an employee based on assumptions that you had about that employee. Assumptions that it turns out, when we pressed you on those assumptions, you couldn't back up. So in other words, you made the decision to discipline based on wrong assumptions or unsupported assumptions which actually are wrong. Well, that's good. That's a good argument to make to a panel or to an arbitrator. Another type of information request which is useful is what I call general request. So we have our list of RFI list. It's got 10 items, and we list 1 to 10. Then maybe 11th request, or you could put it first, is a general request. Give us all documents that you relied on in making the decision to impose discipline. Give us all of your reasons that you adopted the new attendance policy, if we're grieving that attendance policy as being an unreasonable policy, which we have the right to do. We have the right to grieve any decision made by the employer that affects workers, that it was unreasonable. So give us all, and we also have an obligation, have the ability to file agreements if they didn't bargain. Now, that bargaining type of agreements is a little bit in question right now because the Trump Labor Board issued a decision weakening employer duties to bargain during the period of the contract when it adopts new policies or new practices. Hopefully, the Biden board will overcome that or reverse that decision. That was MV Transportation. So in any case, we're going to submit a general request, all reasons for adopting the new attendance policy. Now, we may not get much from that. We'll get a general request, it's not that specific. So the employer might give us 1 or 2 documents or 1 or 2 points and go its merry way. Now we get to the arbitration or the panel, and the employer comes up with a whole new argument or new to make in support of its decision or in support of the penalty put on the employee. Now, We had asked for all reasons for the new policy. We had asked for all documents that you relied on. And now they don't give us anything. Well, they give us one or two things. Now they go to the arbitration of the panel and they come up with 5 new things or 2 new things. Well, we are in a better position now because we made this general request. And we can say to the arbitrator, to the panel, I'm asking you not to consider that argument that the employer made, because we asked him, as we have the right under the NLRA, we asked him for all the documents and all the reasons. He had a legal obligation to give it to us at the time we made the request. He had an obligation to give it to us promptly after we made the request, because the NLRB says the employer must respond to RFIs promptly. He didn't do this. He waited 2 months. We're coming here, and now he's coming up with new reasons and new documents. I'm asking you not to put those in the record, to reject those points. Witness statements. I think we have covered that. There's been a lot of back and forth about witness statements over the years at the NLRB. Do you have to give it to the union? Do you not have to give it to the union? About 20 or 30 years ago, in a decision involving a company called Anheuser-Busch Beer Company, the board at that time, which was a right-wing labor board, issued a very strange ruling, not based on any good legal argument, that an employer did not have to give the names, did not have to give the content of witness statements. If there's an adverse, if they did an interview with a witness, they got a statement from that witness, they did not have to share it with the union. And that was for years, employers would always, when we asked for the written statements prepared by the witness or signed by the witness, they would say, we don't have to give it to you because of Anheuser-Busch. Now, that Anheuser-Busch was overruled by the Obama Labor Board. The Obama Labor Board issued a ruling which wipes out Anheuser-Busch. So the Trump Labor Board, they didn't overcome that Obama ruling. So Anheuser-Busch is bad law. It's no longer in existence. We're entitled to witness statements. Sometimes employers complain that the witness, if I give you the witness statement, you're going to take action against the witness to try to convince or pressure the witness to change his or her story. And we respond, well, you have any evidence that we've ever done that in the past? You don't have any record, any history of that. We don't do that. We won't put pressure on people to lie or change their statements. And you have no proof that we've ever done it. Consequently, it's not a lawful concern on your part. Sometimes we agree to accept a document from the employer, and we sign what's called a confidentiality agreement, so that the employer won't have any basis to object. And in the confidentiality agreement, we promise that the witness statement, because it's somewhat sensitive to the worker, perhaps it will only be shown to the following individuals: the union lawyer, the chief steward, the president, and it won't be publicized or put into any union literature. The board says that employer has to accept a confidentiality promise by the union, or agreement by the union. It has to accept that unless there's any reason, it has any reason to think that the union doesn't meet its promises, that it welches on its promises. And of course, in many cases, I don't think they can do that. Which leads me to an interesting question that came up fairly recently that Ken Path sent me. A worker had informed on a fellow worker, had given information to the employer that the fellow worker, I forget the facts of it, whether he was leaving work early, wasn't doing his work, was harassing, he was doing something that could lead to serious discipline. And when the union asked for the union wanted to get a copy of his statement. And the union also was considering imposing what we could do to that worker for informing. let me step back a second. We have in all of our constitutions, usually, and I think it's definitely true in the Teamsters, provision that says that no worker shall harm another worker. And that means that no worker can bring harm or lead to harm. And that rule means no worker should not inform on other workers and get other workers in trouble. And when a worker does that, the union would have a proper basis to file a charge and to impose its own form of discipline on that worker, which could include as suspension or financial penalties. Now, in the past, I have sort of encouraged unions to enforce their rules against informing. That should be a bedrock union principle, that people don't inform on each other. However, when we take action against an informer, even 1 or 2 times, we have to think a little bit ahead that 6 months from now, we might have another case where there was an informer. And we want the name, we're going to want the name of the informer, and we're going to want this copy of his statement. If we have a history of retaliating against informers, of punishing them, of suspending them, or expelling them, or fining them, probably we're going to find that employers are not going to give us this information in the future. The names of informers, they're not going to require the employer to give us the names of the informers and copies of their statements because of that history. Because there is a grounds for concern that we're going to take action against the informer of that type. And that is sufficient. That would be sufficient to give the employer a sufficient reason to deny our request. So my current position to unions is I discourage you from penalizing workers who have informed on other workers. We're going to have to find other ways to enact that principle or to enforce that principle. That's my current concern. There are some excuses that employers raise that have some merit and that would influence a decision that if we file a charge at the labor board and the labor board has to rule on whether we were entitled to the information, we might lose that case for the following reasons. One, if the employer can show that we sought the information in bad faith, that is to harass the employer in particular. So if we file 100 information requests, if we file an information request with 500 items on it, if we file one after the other, on Monday we file one request, on Tuesday another request, on Wednesday another request. Now, we may think that this is effective because it really bothers the employer a lot and requires him to spend a lot of time in answering our requests. But if in fact those requests are not legitimate or they're not in good faith, they're not really based on a real need. If there's enough situations where we have made bad faith requests, we're going to lose the ability to ask for information. The NLRB is going to deny our future requests on the grounds that our current requests are tainted. Another defense that has merit, we're not allowed to file an information request to support an unfair labor practice charge. If the only reason for asking for the information is to support an unfair labor practice charge, then the employer can ignore the request. And then the third area where we sometimes get stopped is when the employer is able to contend that the information request is confidential. And we've already talked about confidentiality. Well, we can say a few more words about confidentiality. What is confidentiality? Confidentiality is information that is highly sensitive to the employer. That includes trade secrets, its profit, how much profit it made last year. Documents prepared by the employer's attorney are considered confidential and we don't really have access to them. And then ongoing investigation. Let's say that you're called in as the steward to a Weingarten meeting. And at that Weingarten meeting, the employer clearly has some records that it is relying on for asking questions of the employee. Well, we, at that meeting or the day after that meeting, can we submit a request to the employer for records that the employer is reviewing as part of its investigation of the employee? Now, mind you, at this point, no action has been taken against the worker. The company is investigating whether to impose discipline. Are we entitled to records before discipline is imposed? And the board's current ruling is no, that those records should remain confidential until the employer makes the disciplinary announcement. Once it makes the disciplinary announcement, yes, those records have to be turned over. But while it's still in the process of investigating, I mean, for example, if you're the chief steward and you're called in and the employer says, we've had several reports that you are abusing workers or that you are threatening members of the bargaining unit, do you have any answer to these charges? Well, does the employer have to give you the information as to the names and the content? Now, they haven't imposed discipline yet. Or you leave the meeting and you say, gee, I want to know who made those complaints. Does the employer have to give those to you? The board's current posture is no, because they're still investigating you. Now, once they decide to impose discipline, or once they decide they're not going to impose discipline, yes, then at that point, certainly if they're imposing discipline, we are entitled to the records. If they decided not to impose the discipline, we are entitled to the records in order to review whether the investigation was discriminatory. After all, they can't discriminate against us. They can't investigate us, because an investigation of a worker, and especially the investigation of a union officer, is harmful, it's painful, it's embarrassing. We want to make sure that you don't just investigate a union officer without a basis, without a lawful, fair basis. So yes, even if they turn us down, we want those records. We're entitled to them after the fact. Okay, let's talk about information about persons outside the bargaining unit. This is a big area, and what we're talking about here is that, yes, we know that we're entitled to the records of other employees who committed the same types of misconduct and got lesser penalties. Are we also entitled to the records of persons outside the bargaining unit who committed similar offenses and got no discipline or lesser discipline? For example, if a member of the bargaining unit is given a 5-day suspension for smoking on the job, or smoking in a room where he shouldn't be smoking, we may not have other workers in the bargaining unit who did the same thing and got lesser penalties. But we know that there were supervisors who were caught smoking, or there were engineers who were caught smoking, or there were accountants who were caught smoking, or members of management who were seen smoking. We would like to have everything we can about those employees. We would like to know the nature of their offense, the nature of the investigation, and the nature of any penalties imposed. Are we entitled to records about supervisors and people outside the bargaining unit? The NLRB says yes. Says that we are entitled to records for people outside the bargaining unit if they are subject to the same rule that the bargaining unit that covers the bargaining unit. Say a no smoking rule, well, no one could dispute. No smoking applies to everyone in the shop, everyone in the facility, union and non-union. So certainly, if they've enforced that rule in a lenient manner towards supervisors or non-bargaining union members, that's relevant, and we're entitled to the records of their investigation and any penalties imposed. Coming to work under the influence, that's obviously a rule that applies. Harassment, if we were defending an employee who's accused of harassing other workers, or a man who's accused of harassing female workers, and we know there's a supervisor who did the same thing, we want his or her records. We want her file. We want to see what was done to her. And if there was a lesser penalty, we want to know why.